Usman Qureshi, and I'm an attorney. I practice in the area of estate planning in the Dallas area, and I have actually a satellite office right here in Cedar Park. Recently opened up an office here as well. So, inshallah, today we'll talk about an important subject which is often overlooked because most of us, unfortunately, suffer from what I call a Superman syndrome. We think that nothing is going to happen to us, and that when someone passes away, that's for somebody else, not to me. It can't happen to me. But we know that that's not true. Everybody's got to go. So it's better to have yourself prepared for that inevitable event that will happen. So in the beginning, I began with the ayah, and inshallah I'll talk about the ayah in a few minutes. But I want to talk about a couple of housekeeping rules. And I think you can see, my screen. The format of the presentation is going to be, inshallah, a 15 to 20 minute of presentation where I'll talk about a few basic items, components of estate planning, what is included, what should be thought about and considered. And then the second part, which is going to be a lengthier part, will be the Q&A, in which I will ask questions. In fact, I won't ask questions. You will send me questions through your phone, and then I'll try my best to answer them, inshallah. So with that, let's begin. As any good attorney should begin, we should begin with a disclaimer. And these two things that I want to mention, that the information that I'm sharing with you is not legal advice. It's not intended to tell you how you do this, but it's not an instructional video or presentation. It's to give you some basic general ideas on the topic of estate planning. What is a will? What is a trust? And so on and so forth. And secondly, it's not something that's an exhaustive that's going to cover everything on the subject. It covers major issues that are maybe related to you, to most of you. And there may be other things that I may not be able to get to in this 15 or 20 minutes. With that in mind, I have broken this presentation into two questions. Why should I and how should I? So the first question, why should I? And we will try to answer them in the light of Quran and Sunnah. And how should I? And then we'll talk about a few things we should be thinking about when preparing these estate planning documents. So the first and foremost, why should I write a will? Well, we know that, maybe we don't. A lot of times people don't know this, but this is a direct verse in the Quran that talks about this very subject, right? And that's the ayah that I recited in the beginning, which talks about, specifically it says, it is prescribed when death approaches any of you, if he leaves any goods, that he makes bequest to parents and next of kin, according to reasonable usage. This is due from those mindful of God. And this is referring to Quran, Surah Al-Baqarah, verse number 180. So we get our direct source from the Quran telling us that, hey, you should do it. Why? Because it is good for us. It will simplify things for us, right? So there's a direct command, if you will, or instruction for us to do this in the Quran. In addition, we also find a hadith in Al-Bukhari which says, it is the duty of a Muslim who has anything to bequest not to let 2 nights pass without writing a will about it. So many of us have let more than 2 nights pass, right? And haven't not taken an action to get this thing done. So I urge you to consider it and inshallah get your estate planning, which is will, trust, whatever you would like, prepared. Now, in terms of, from a legal point of view, so we talked about from a religious point of view why we should do it, and we talked about an ayah of the Quran and a hadith. But legally speaking, what are the practical consequences of not having this done in your lifetime? So these are some of the things that I put up. These are some of the questions that, a couple of questions that I ask for people. If you care who gets your wealth, if you pass away, you die, if you care who your wealth belongs to, who it goes to, then you should write about it. If you don't write about it, someone else is going to decide who gets your wealth, not you. Second question is that, do you care who takes care of your children? And this question is more often more important than the first one, because our most important asset is our kids. So most people, when they come to me, they say, I don't care about what happens to my money. They do. But not as much as the second question is like, what happens to my kids? Who is going to take care of my kids, especially if they have minor kids, young kids? So if the answer is that yes, you do care, then you've got to write about it. Otherwise, someone else is going to take care of your kids, somebody you may not like or you may not agree with. And here I mentioned that a judge can appoint a guardian for your minor children and not yourself. And a third point under the legal consequences is that if you don't have a will, then it can get complicated. It can get complex. Because think about it. If you haven't written down something, if you have not given a roadmap of what should happen, and somebody else has to figure it out for you, it's going to take time, more time. It's going to have expense associated with it. It's going to have possibly conflict, because you may want one thing, the person who may be doing this for you may have a different idea. So it can be expensive, time-consuming, and it can involve family conflicts or quarrels. And then in the form of court hearings, depositions, trials, and so on and so forth. So, simple point, let's get this thing done. It's one of those things that people don't want to think about. That's why when people come to me, and then we have a sit down together, after we are done with our discussion and our finalization of the documents, I would say 95% of the people say, we have been thinking about doing this for 10 years, or 5 years, or 7 years, or this many years. Now we feel this burden lifted off of our shoulder. Okay? So this is something that, inshallah, you will feel benefit from, not yourself as well as your family. So let's get this thing done, inshallah. So the next question that I posed at the beginning which is, how should I? What are the things that I should be thinking about when having this, when preparing to write a will or prepare a trust? There are some of the things that I write down, and we're going to talk about some of these things in turn and one at a time. So these are some of the things we want to talk about. We want to make sure that we have an executor. We have somebody who is going to be a legal representative of us, who's going to make sure that if something happens to us, they can legally represent us. And that person is called an executor. So you want to select an executor. You want to identify your heirs, assets, liabilities, and also identify a guardian. Guardian is somebody who takes physical custody, who takes charge of your minor children, anybody who's under the age of 18, or somebody who suffers from mental illness, or who is adjudicated to be not a competent individual. That person will require a guardian. So these are some of the things that we identify or think about when we are thinking about writing our will. Now, as I said, we're going to talk about some of these items because they are worth talking about at length. So let's talk about who is an executor / guardian. So again, as I mentioned to you, executor is somebody who is responsible for distributing your assets. That's one aspect of your legal representation. That person represents your interests, again, sort of winds up the affairs of the deceased person, the person who has passed away. And one of the affairs is that whatever they left behind, that person is responsible for distributing those according to his or her wasiyya, the will. The second person, as I again already mentioned, the guardian is somebody who's responsible for taking custody of minor children under the age of 18. Some criteria, some points that people ask me about, well, how should I pick somebody to be my executor or guardian? And I tell them that can be, the executor or guardian can be an heir, meaning he can be or she can be a family member, can be son, daughter, spouse, could be a brother, sister. So can be an heir, somebody who may receive from you, but does not have to be. Okay, it can be a friend. A lot of times I get asked this question because a lot of us, have family overseas. So we don't have family or relatives close by. And in that case, I recommend naming somebody, a friend or close friend or other relative who can perform the duties of an executor or a guardian. Somebody Muslim, not required but recommended, somebody who's going to understand your values, your beliefs, and can really implement what you wish, what you want. So that's one of the criteria that I put there. Another point that I mentioned is that the executor or guardian doesn't necessarily inherit anything. So if you name your brother to be the guardian or executor, that doesn't mean automatically he's going to get your stuff. Okay? He also has to be a beneficiary. He has to be an heir in order for him or her to receive anything from you. So a lot of people think that, okay, as long as they're named in the documents, then they get stuff. So that's not the case. An executor or guardian, you can think of them as an administrator. They only do what you ask them to do without receiving any benefit. Another or last point, I guess, in this on this slide is the local versus overseas. So as I mentioned earlier, we have family members overseas, whether it be India, Pakistan, or anywhere else in the world. So people ask me, well, can I name my brother or my sister or my uncle, my aunt, my father, mother, who's living overseas? I tell them, if that person who you're naming cannot come here, cannot come to the U.S. to perform or to assume the duties that you want them to assume, then that person is not suitable. The person should not be named, should not be appointed as the guardian or the executor. Now, there are ways around it, meaning you can have somebody who's named here in the United States to act as a temporary or transient guardian, and you can have a more permanent guardian overseas, if that's what you wish. So there's a way to get around that dilemma of I want my brother or my father or my mother to be, but they're not here. So we can talk about, if you have this situation, we can talk about having some sort of like a dual guardianship where you have a U.S. guardian and you have an overseas guardian. That is possible. The next thing I want to talk about, it is now getting away from the how should I question, this concept of probate, because this will become relevant in our discussion later on. So the process of probate, or the proceeding process of probate, it's a court process, a court procedure, and it's designed to make sure that the documents that you prepared in your lifetime are authentic. They're real. They're not made up. They're not forged. So there is this court process that has to be followed when somebody passes away and they leave a will behind. And it does these things. It verifies that the document is authentic. It implements whatever you said in the will. It implements the process. It implements the wishes that you listed or the instructions that you outline in the will. And then it settles matters of the deceased, which means that if you owed any money to somebody, you owed money to somebody, or you had some other legal affairs, you had a business, and somebody has to now close it up or wind it down or sell it, whatever the case may be, that's settling matters of the deceased, legal matters of the deceased. So this is the process called probate. And again, the reason why I talk about it is because it becomes relevant in our next slide. So a lot of people ask me, and you may have also heard of this term called a living trust. Okay, I just added the word Islamic because as long as you do everything, as long as your instructions are according to Islamic principles, the living trust becomes an Islamic living trust. So what is a living trust, and why have a living trust and not a will? So the living trust allows the person, or the person who's setting it up, it allows the person to manage the assets in the lifetime. So you can do certain things in the trust and say, okay, this asset is designated for this purpose or for this person. Okay, and it can have some management functions you can define inside the trust for that asset. Another feature of a living trust is that it can do incremental distribution. It can do distribution over a period of time versus having distribution done in one time. Let's say at the passing of the deceased, let's say you have kids who are minors and you want to delay that distribution until they become adults, the trust can help us facilitate that process. And then it can distribute assets upon the death based on Sharia. As I mentioned, if what you say inside the trust is according to the Islamic principles, then that means you have an Islamic living trust according to Islamic principles. And lastly, it can avoid probate and all the issues that probate brings, which I have listed some of them. So in the previous slide, I mentioned to you what a probate process is. It's a court process of implementing your wishes. That process can be costly, it can be time-consuming, and it can bring a lot of hassle. So many people want to avoid that process. 9 out of 10 people who talk to me and have a discussion with me, and I tell them what is a will and what is a trust and the difference between the two, we come to a conclusion that setting up a trust is much better than having a will prepared. Okay, so to illustrate my point, to make it more clear, I created this flow chart, okay, and which kind of explains the differences between a will and a trust in practical terms. If you have a will prepared, you can see on the left-hand side, if you have a will prepared, and I told you that when someone passes away, that will has to be taken through the court, and it has to be implemented. Whatever the wishes are have to be implemented through the probate process. And then the arrows that are pointing down represent the assets. So the assets come out of the will, go through the probate, and then to the heirs. Whereas on the other side, the assets come out of the trust and go directly to the heirs. There's no probate, and you can avoid the cost and hassle and time that's required to do the probate if you set up a living trust. So with that, these are the items that I wanted to share with you, and I'm right at 20-minute mark. What I want to do next is I want to talk about some of the questions that I get asked, some frequently asked questions. And I'll go through them very quickly, and then I'll open up the forum for the others to ask me questions, individual questions. Is Sharia compliant will valid in the United States? And the answer is yes. There's no prohibition for you to have an Islamic, a will that is based on Islamic principles. The Constitution gives us the freedom and the protection that we can do or feel and practice our religion and our beliefs, as long as they're not contrary or illegal and against or violate the Constitution itself or any laws of the United States. And having a will prepared according to Islamic principles does not violate any US laws. Some people ask me, can I use something found online, template found online? The answer is yes, you can. But the right question is, should you? And the answer to that question is no. Because this is probably, after your marriage contract, I would say, this is probably one of the very most important documents that you will write in your lifetime. Okay? For afterwards. So you want to talk to somebody, or you want to have this document, you want to think about the things that go into this document rather than doing using a template online, which may not have everything that you want, which may not tell you what you should be looking out for. What you don't know, you don't know. Okay? So I tell people, yes, you can, but I advise against using any type of templates found online. Third question, can I include overseas beneficiaries in local will? And the answer is yes, you can include your mother, father, brother, sister, family members as beneficiaries in your documents. There's no problem with that. The following question is, many of us have, like I said, we have family members outside of the country, and we have assets outside of the country. So we wonder, can we have, does my U.S. trust will or documents cover outside of the U.S. assets? And the answer is no, they do not. The assets that are outside of the U.S. have to be addressed in that local country. The issue is not what you do with the documents. The issue is with the enforcement. Let's say you have a document prepared based on U.S. law, and you have a property in Saudi. If the will that's prepared under U.S. law is made here in English, based on U.S. law, is not going to be recognized by the Saudi government or the Indian government or Bangladeshi government, right? So the document has to be made under the laws where the property is located. So it is not practical for you to have a document, and vice versa. Let's say you had a property, let's say you have a property outside of the country and in the United States, and you had a will prepared in another country. Well, you couldn't just bring that document here and distribute or do what you want to do with your home here in Austin. Nobody in the Williamson County or Travis County is going to recognize the document which was made in India or Pakistan, right? Not going to recognize it, not going to enforce it, not going to accept it. Same thing with the document made in the U.S. Will not be recognized outside of the country. Another question I get asked all the time is that how do I make updates to these documents? And the answer is there's a simple procedure called an amendment process, and we can make any changes to your documents. And a lot of you may have some documents already prepared. Well, how do I make changes? There's a procedure, simple, straightforward procedure to make modifications or updates to your documents. And then another question I get asked, and recently more so, and especially in areas like this where you have a lot of tech presence, is if I accept legal insurance plans, and there are some of the ones that I mentioned on here, and I do accept these. If you are working for an employer who offers these plans or legal insurance, then I accept them, and I can give you more information on them privately, one-on-one. And then I put another option at the end, at the bottom here. There's something called Texas Legal. That's an organization, it's a nonprofit organization that allows or gives the ability for you to take insurance plan with them, which you can use to have these documents prepared, which is very beneficial. And again, I'm part of Texas Legal Network as well. So I just listed the information there if anybody's interested in going to their website. So with that, probably the hottest question in everybody's mind is that, well, what does this cost? How much does something like this cost me? And I talk about it in my Next slide. So I tell people that just roughly, again, as an estimate, between $1,800 to $2,000 to have an estate prepared, okay, by an attorney. This includes all of the documents, legal documents, advice, and so on and so forth. And I included some points that you can read. There's some, of course, there's some limitations. It has to be, you have to have one property, not more than that, because additional properties create additional work, and that adds cost to the fee range that I've shared with you. And of course, there's some good news too that I've put up at the request of one of the brothers of your community. He mentioned to me that some people are interested in having some sort of a ICBC group rate. So I thought about that, and I put that there for your consideration. Of course, there are a couple of restrictions that are there. I'm often, not often, but sometimes I give these lectures, and then 2 years later, somebody calls me and says, you know what, brother, I saw you 2 years ago before COVID, you know, can I become part of this, whatever khair that you are giving out? And I tell them, no, there's a limit to the khair, and the limit is listed up there. With that, I will now turn it over to the group, to the attendees. The way you will ask me questions is through this, the phone number. So I have access to this, to the messaging system. So whoever has a question, they can go to this, go to your phone and then compose your question and please send it to me, and I can answer them one at a time. So if it won't fit on the message, then maybe we'll talk about it. If it's going to benefit the group, maybe you can ask me. But if it's not, then we can talk about it one-on-one. Sure. Wa alaikum assalam. Yes, go ahead.
It's on. Okay. Assalamu alaikum. Thank you for the presentation.
Wa alaikum assalam.
You mentioned that the process of will go through several steps, implementation of the will.
Yes.
And trust is very straightforward. Why would anyone want a will in that case?
Why? Sheer ignorance is the driving factor. People don't know what a trust is. Everybody knows what a will is. So a lot of times it's just people don't know. And they go for something they know without knowing that there's a more efficient, better option. So it's just all about not knowing. That's one of the big things that drives people preparing a will and versus a trust. Second thing is that people who don't own any real estate, if you don't have any home or real estate, then you can get away with just having a will prepared. So, but as most of us here, sitting here today, probably I would say, I guess maybe 90% of us have some sort of a real estate, something that we own, whether real estate that we live in, home that we live in, or an investment property. So that's why I assume that most people have it. So those are the two main reasons. People don't know, and people who have simpler or no non-real estate assets or estate. So I am now getting questions. Inshallah, I will. One question that I got just now is how to prevent inheritance tax. So inheritance tax is a subject which is, generally speaking, outside of the scope of this discussion. It's a complicated question and involves tax laws and tax rules. But the idea is that we can set up trusts. So, okay, what is an inheritance tax? Inheritance tax is a tax that you pay upon your estate when you die. But the inheritance tax is only applicable over a threshold amount. So if your estate has over a certain amount, currently the threshold is 12 million. If the estate is over 12 million, then we have the inheritance tax problem, okay? And we can address that through the trusts. But if the estate is below that threshold, then obviously we don't have to worry about. So how do you avoid it? How do you prevent it? Is through not having so much money. And number two is by having some trust prepared, which can help you with that. Another question is trust per state? Does it mean we have to move out of, okay. So the trusts that are made, any trusts that are made in one state is valid in all other states. So if you make a trust here and you move to California, it'll still be valid in California, and vice versa. If you move from somewhere else, your trust from outside of the state will be valid here in Texas. Next question, if I have a joint account with my wife, is that still eligible for distribution to my beneficiaries? So if the question is that you wrote in the answer is yes. Your portion of that account. So if you have a joint account, that means you're 50-50 on that account. So your 50% is still subject to the distribution, and that will be distributed according to whatever instructions you left behind, and it'll be distributed to the beneficiaries. So the next question asks about this Texas legal insurance that I mentioned earlier. How could you expand on how Texas legal interacts with the cost that I mentioned to you about the $2,000, and what is the approximate premium? I would urge you to go to the website, whoever asked this question, and look at whatever I'm not an advocate for that company. I don't work for that, or I don't sell anything for them. But a lot of people ask me, hey, is there an option? So I just happened to find this one, and I gave you the option. But I would recommend that you go to the website, look at their options, look at their plans, and do that. Now, I will say that there is, with the cost that I mentioned to you, with the insurance, some sort of insurance plan, there is about, I would say, 70 to 80%, which is covered by the insurance. There's a small percentage that you pay. So hopefully that answers the question, the first question that this brother asked. If Living Trust, is Living Trust the same organization who will take care of the will and all possessions? Yes. Through the Living Trust, you can have your distribution be completed. You can have your distribution be included inside your Living Trust. Another question is, the Texas estate where accepts handwritten documents, why should we choose? Okay, so this is a very good question. Texas is one of the states where you can have a holographic will. That's what it's called, holographic will. It means that a will was written by hand, okay, completely by hand, all right? Now, although it is acceptable to have a handwritten will, it can be easily challenged. Now, you can imagine if you have a will by, let's say somebody passed away and a piece of document showed up with just some scrabbles written on it, naturally you will look at that document with suspicion. Where did this come from? Is that real? Is that handwriting of the deceased who passed away? So while it is allowed legally to have a written will, handwritten will, it's not recommended because it can be easily challenged for reasons I just mentioned. The handwriting could be in question. What it says may not be sufficiently or properly written. So I don't recommend having a holographic will, and that practice is really almost outdated. Nobody writes their will by hand. Second question: what if my chosen guardian passes away after taking over my kids? So, in the will or the trust that we form, we name multiple people, one after the other. So if one passes away, the second person can take over, or the third person, and so on and so forth. Can you appoint more than one executor? I just mentioned that. Yes, you can. Does an amendment to the trust cost money? Yes. The answer to that question is yes. Does the trust apply to one person or does it apply to both parents? So there is something called either joint trust or single person trust. You can have a joint trust for a husband and wife, and that covers husband and wife and their assets together. Is your will or trust become part of public document? This is a very good question. A will becomes public record upon the death of the person. So when you pass away and your estate is going through the probate process, that's where everything becomes public. Whereas trust never becomes public. It's a private document that remains within just the family members. It does not become public at any point. How do I distribute a running business Islamically? Okay. For example, between 3 sons, and if one son is running it and the other 2 have jobs or generally is okay. So I think this question is asking if you have a running business, so you have a restaurant or some active business that you're running and you have, how do you distribute it? Well, the will or the trust that you prepare will have the term or the formula, how it should be divided, based on if you have male children, female children. And 2, if you have an active person who is running the business, that person can have a compensation for their work. So inheritance has nothing to do with their sweat equity, meaning what they're providing to the business. They can get compensated for the services they're providing to the business, and then at the end of the day, the business itself can be divided among the kids based on their Islamic inheritance shares. Next question, should the wife and husband make a separate trust? I think I answered this question already, that you can have a separate trust for each spouse or you can have a joint trust. There are some pros and cons. Mostly, I would say that if both spouses are working, it makes sense to have a separate trust. So that could be one of the criteria. If both spouses are working, it may make sense to have a husband trust and have a wife trust. That way you can have separate assets in each trust. If all assets belong to one of the spouses, does the trust still need to be approved by the other spouse? Very good question. I'd like to know who asked this question. Yes, if it's a joint trust, that means both husband and wife are making the trust together. So if you have assets belonging to only one spouse, then you can opt to have a single person or separate trust. But keep in mind, we live in a community property state where everything is 50-50, okay, by law. As soon as you get married, as soon as they say, I do, it is done, okay? So that means that 50%, even though you might think that you have all of the assets or the assets may belong to you, okay? I have news for you, all right? The other spouse has 50% interest in that asset. So yes, you need signature for both in that regard. But again, this is more of a complex question. Maybe we can discuss one-on-one. If parents are citizens of India and children are citizens of USA, can they still make a trust? Yes. There's no restriction on requirement of citizenship. As long as you're here in the US, you have US-based assets, you can create your documents here. Next question, does the quoted cost include assets other than property, for example? Yes. The cost that I mentioned, it includes all types of assets. Just the real estate is only one. If you have more than one real estate, then the cost increases. Otherwise, everything else, accounts and so on and so forth, are included. Can you include health decision assignment in case you're in incapacity? Yes. So the question is asking, what if something happens to me physically and I want somebody to make medical decisions on my behalf? There's a separate document called Advance Directive or Medical Power of Attorney. So I prepare that as part of the estate planning documents. The cost that I put up there, it includes those those documents. Okay. So there's another question that says, please share the form link to fill. The form is right there. There's a link right there which says, and then the next steps, which says there's a HTTPS address. If you can take a picture of that and go to that form when you get home and fill out that form, that's the form that I'm talking about. This is a good question. Is there going to be an ongoing cost with any maintenance cost with the trust? And the answer is no. There's no maintenance cost attached to having a trust. There's no fees that you have to pay annually. This is a one-time cost, and that's it. How many guardians can be listed as primary, secondary in the event primary process? You can have as many as you need. You can have 1, 2, 3. Mostly I see like 3 people after your spouse, or actually it's 2 people after your spouse, so then you have a total of 3 people. So you can have the other spouse, surviving spouse as number 1, and you can have 2 additional people named as the guardian, but you can have more if you like. There's no like limit that you have to follow. Does the trust file a tax return every year? Again, a good question, and the answer is no. The type of trust that I set up does not have any tax filing requirements. It does not have its separate existence from you. So there's no tax returns for the trust itself. The house we live in is under my husband's name and my name. So 50-50, okay? It's a jointly owned house. What happens if one spouse passes away? Does the living partner and children have to give up the house for the proper distribution of the assets? And the answer is yes. That can be the case. If that's all the assets there is, if the only thing that the husband and wife own is this home, jointly owned 50-50, then the 50% of the deceased now will have to be distributed. Now, there are some things to think about. I mean, it's not a very simple yes or no answer, yes or no. But generally, yes, that's what's going to have to happen. The deceased has passed on. Now the asset has to be either liquidated, or the ownership of the home needs to go in the name of the beneficiary. So now if the surviving spouse and let's say the parents or whoever the beneficiaries are, the ownership can now be of the home can be in the name of the beneficiary. So in that case, maybe the liquidation or the selling of the home may not be required. But this is not a very simple question. I can elaborate on that one-on-one if you approach me. How long does the process take to prepare the trust? I normally tell people 3 to 4 weeks as a general rule of thumb from the time that you provide me all the information, about 4 weeks to have everything set up. And this appears to be the last question unless I get more questions. Oh no, there's one more. Can we include estates in other countries in the will? The answer is no. I mentioned this earlier. The assets that are located outside of the U.S. must be handled in that country by the laws of that country. If the property is owned by a living trust, can the trust have anonymity? Yes, the trust can provide anonymity, meaning hide the owners, hide the name of the owners of the property. So it is possible for a trust to provide anonymity. How and why, and that's something we can discuss one-on-one. What's the cost of amendment to the trust? Generally, $100 to $150, depending on what you're trying to amend, the change that you're trying to make. My wife bought a house using her inheritance. My understanding that this is not a joint shared assets. That's correct. That is a very good question. So I mentioned earlier that in the state of Texas, everything is 50-50. There's some exceptions to that rule. One of them is inheritance. The other is gift. So if you, let's say husband and wife, you own a home together, that's a jointly owned property that you bought during marriage. But let's say one of the spouse's parents passed away, and that spouse inherited $100,000 from the deceased parent, that $100,000 belongs separately and only to that recipient. The recipient child does not belong to both husband and wife because, again, inheritance is considered separate property of the recipient. 50% of the wife of a share is not Islamic way. How will that be enforced and handled? So, as I mentioned, 50-50 between husband and wife. If both wife and husband agree, then we can convert that 50-50 to anything that is agreeable between the parties. So, example, a house is owned 50-50. A house is owned entirely by the wife. Let's say wife bought it with her money, husband contributed no money. So Islamically, it belongs to the wife. But Texas says that it is 50-50. So I can prepare an agreement or a writing which says that we're not going to follow Texas 50-50. We're going to follow the actual ownership, which is wife gets 100% and husband gets 0%. The 50-50 rule applies to personal home as well as other property. That is correct. The 50-50 rule applies to everything that you own during marriage. And this is probably one of the last questions, inshallah. I know that we've got the Isha time already started, so we will close with this last question, or maybe one more. As the values can change over time, or over a period of time, I'm sorry, let me read this question correctly. In the will and trust, you disclose the assets. So it says that in the will or trust, you disclose asset values or just the percentage. So we don't disclose any values because, as you rightly pointed out, that the values is going to change every month. So the documents don't include values because you'll be changing or updating your documents every month. So with that, I think these are all the questions that I could answer in this period of time. Other questions that I receive, I can see if I can reply reply to the message, or you're welcome to, send me a message or contact me through one of the contact information there, and then we can address more questions that way. So thank you so much for your time and for your attention and for your patience, and inshallah, hopefully this was beneficial, and let's take the next step. Assalamu alaikum wa rahmatullahi wa barakatuh.